Good afternoon. Thank you guys all for joining us. Over the last couple of weeks, we've received quite a number of inquiries, phone calls, emails from members about the immigration bill and how it will impact our community in particular. Obviously, workers of all stripes are important to the construction economy and our businesses. And the recent bill on immigration is going to have a material impact on our business. And we thought it was really important that we get together as a community, as an association, and talk about the bill, talk about the impacts of the bill, and try to get the truth of the bill and the facts out in front of people. There's been a lot reported in the media, some of it a little bit exaggerated, some of it intentionally driving fear among much of this community. And I thought it was important, as did the rest of the board, that we get out in front of it and try to provide resource to our members. To that end, we have this webinar set up today. We've had over 400 people subscribe and sign up for the webinar. So thank you guys all for joining us. We're happy that you can be part of this association and all that we're doing. It's particularly concerning for me what's happening, where we have a governor who has been very good for our business in general, but who has seemed to take his eye off the ball and focus more on his presidential aspirations than his constituents with regard to this bill in particular. So I thought it would be a good idea to get Angelo Filippi from Kelly Cronenberg on to discuss with us the reality of the bill. Angelo is a partner and business unit leader at the firm of Kelly Cronenberg. He's been a friend and advocate for our association for many years. He's someone that many of us turn to when OSHA issues come up, and he's part of our monthly safety sessions, our Wednesday safety sessions with regard to OSHA issues. Today, however, we're leaning on his knowledge around employment law and how this will all play out for our community as the bill takes effect over the coming months. So with that, I will turn it over to Angelo. And if you have questions, please put them in the Q&A. I'll try to be fielding those questions and bringing them to Angelo's attention as he works through the bill and how it impacts us and the PowerPoint that he has prepared. But like I said, please raise your hand, or better yet, put it in the text message Q&A. And if we have time and if it fits the agenda, we'll make sure we address it. So with that, Angelo, please.
Thank you. Good afternoon, everyone. Glad to be here. Hopefully I will shed some light on the impact or issues relating to this immigration law now that is in effect, and will begin to be implemented starting on July 1. It's interesting that I've been practicing employment law for closing on 40 years now, and one of the areas that I work with some clients on is I-9 issues. And the interesting part of it is in the years that I've practiced, it's probably one of the least number of questions that I field from clients with regard to their employment practices. So it was interesting to me that all of a sudden we've got 400 or so invitee or people who want to participate in this seminar this afternoon to learn a little bit about what this immigration bill is, and the primary focus of the bill being the use of I-9s, or one of the primary focuses. I want to start out, though, by talking a little bit about the hiring process itself, because I think it's one of the areas in my field that employers spend the least amount of time analyzing from the perspective of what are the risks, what are the legal issues. Not many pay attention to it. For example, how many of you can tell me what you can and cannot ask on an application? What is illegal to ask on an application? Can you ask for someone's date of birth? The answer is yes. Would you want to do that? The answer is no. Why? Because asking for a date of birth might then become Exhibit A if someone claims age discrimination. But it's not illegal in and of itself. Can you ask if someone needs an accommodation to perform the essential functions of their job? No, illegal under the ADA. But you can ask if they can perform the essential functions of a job with or without an accommodation. Seems like semantics, but it's not, according to the EEOC. Can you ask, have you been convicted of a crime in the past 5 years? Yes. What can you do with that information? And therein lies the rub. Use of that information to reject an applicant has to be supported by business needs. Can you ask if someone is a citizen? No. That's prohibited by IRCA, the Immigration Reform and Control Act of 1986, which forms the basis and foundation of the I-9 and subsequently the E-Verify system. I-9s and E-Verify are enforced, or the laws that surround them are enforced by Homeland Security in the federal sector. There are issues surrounding I-9s that, again, I think employers in general don't pay a lot of attention to. For example, if someone has provided at the beginning of their employment a permanent resident card, a I-551, or an employment authorization card, that's I-766, those documents expire. When they expire, do we know? Do we have a tickler system as an employer? Because at the moment they expire, you are now employing someone who's not authorized to work. And since you have a record of that, do you now know that you are employing someone who is unauthorized to work? The answer could be yes. That becomes important not only within the federal law, but also within the new state's immigration statute. The federal law. And as soon as I figure this out. Okay. So the federal law, the Immigration Reform and Control Act, as I mentioned, prohibits hiring or continuing to employ individuals who are not authorized for employment. It prohibits hire without verifying identity and employment authorization. So, and requires the use of an I-9, but does not require retention of documents. So at the beginning of someone's employment, the federal law, just as the new state law, requires you as an employer within 3 days of hiring an individual to verify their identity and their employment authorization and to complete an I-9. It doesn't require that you retain those documents, but my recommendation and advice to clients is that you do retain those documents. Why? What happens if at some point there is an audit by Homeland Security and they assert that you're knowingly employing someone who is unauthorized? You can produce the documents that you relied on to fill out the I-9 if you retain them together with the I-9. And as long as those documents reasonably appear to be genuine, then you are not knowingly, under the law, employing someone who is unauthorized to work. Now, we've all seen, I'm sure, some of the documents that are presented to us that maybe are a little askew or maybe the names don't match on the two different documents, or something that makes it clear that the documents are not genuine. In those situations, then you do not have sufficient information to continue to employ that individual. So again, the key here with respect to the I-9, at least, and I think as we will see later on with the state law, is that you obtain documents that reasonably appear to be genuine and use that either to fill out your I-9 or to e-verify. E-verify was established back in the 90s. It's an internet-based system operated by Homeland Security again. So on the e-verify system, you verify employment eligibility by entering data that is also required by the I-9. Again, you have to enter a document that establishes identity and a document that establishes authorization. In most instances, what you're going to be entering is someone's driver's license, which establishes identity, and a social security number, which establishes authorization. Unless, of course, that social security card says right on the face that it's not sufficient to authorize employment. The documents that I mentioned, the permanent resident card, the 551, and the employment authorization card, the 766, can be used for both purposes. Why is that important? Well, we've seen in the new law that there are issues with respect to driver's licenses. None of these issues have been implemented yet. We certainly don't know yet how enforcement is going to occur, how it's going to be interpreted. So someone who doesn't have a valid document, perhaps a social security card that's not valid, or someone who is unauthorized cannot have a valid driver's license, and you can't use that driver's license to establish identity. Even before this law was signed by the governor, there were already states that require all or most employers to use e-verify. I've listed them there. There are also states that, including Florida, that previously required public employers and or contractors with the state to use e-verify. And there were a couple of states that required public employers only. So the trend is for the states to require private employers to use the e-verify system. And we're going to see others joining the list, including Florida, which has just joined it, that require all or most employers to use the e-verify system. And again, I want to repeat and emphasize, the e-verify system simply takes the same documentation that you use on an I-9 to establish identity and eligibility to work. And those documents have to simply reasonably appear to be genuine in order for you to use them in the e-verify system. Now, e-verify is going to tell you whether or not those documents are genuine. So if you're just using an I-9, if you're an employer with less than 25 employees, if you're just using an I-9, you can still establish that the documents that you have and retained reasonably appeared to be genuine, and therefore you can employ that individual. But now, if you have more than 25 or more employees, E-Verify will tell you, once you enter those documents into the system, whether or not that person is in fact authorized to work. The law that was just passed and signed is effective July 1. It is not retroactive. What does that mean? That means that those people who are currently employed and for whom you have perhaps filled out an I-9, those documents reasonably appear to be genuine, can remain employed. You do not have to enter those individuals or employees into E-Verify. What if you rehire someone? If you rehire someone, we don't know how the state is going to implement, but I would presume that the law here is going to be construed broadly. Therefore, if you rehire someone, you will have to put them into the E-Verify system. So the law requires private employers with 25 or more employees to use the system to verify a new employee's employment eligibility. And I emphasize new, because again, you do not have to put your existing employees into E-Verify. Now, if in the past you've used E-Verify, and the requirements of E-Verify under the federal system are that if you use it for one, you must use it for all. One will have to presume that the state law is going to interpret it the same way. So actually, the state law is going to say that if you have 24 or more employees, every single new employee will have to be put into the E-Verify system. Are there any questions at this point?
Not at this point that fit with the topic yet.
Okay. I see some questions on the.
Not so far, Angelo.
Okay. Okay, so employers must retain, under the state law, employers must retain a copy of the documentation provided. You are required to keep them for at least 3 years. The federal system says, or the federal law says, that the requirement is 3 years or 1 year after termination, whichever is longer. We're going to presume that the state law, which just says at least 3 years, is going to be interpreted the same way. So if you have an employee who you terminate after a year, you have to keep his or her documentation for at least 2 more years. If you have an employee of 10 years who leaves your workforce, you'll have to keep his or her documentation for at least another year. Again, even if we were just traveling under the federal system, I've always recommended that you maintain that documentation, because that's your primary defense to a claim that you knowingly hired someone who is not authorized to work. as long as those documents that you've retained reasonably appear to be genuine.
So, Angela, does this apply to companies located in other states that do not require E-Verify that are hiring Florida employees to perform work in the state of Florida?
If the employee is going to work in the state of Florida, even if you are an out-of-state employer, it would apply, yes. And that's presuming that you're licensed and authorized to do work in the state of Florida.
Okay. If I have employees in multiple states that total more than 25, but only 5 in Florida, do I still need to comply with this law?
That's a good question. And it remains to be seen whether or not or how the state is going to interpret the 25 employee requirement. So typically under labor laws, if you have a single entity that is employing more than the requisite number of employees, then for purposes of counting the number of employees for any state or federal labor law, you would count all of your employees. But again, we don't know yet how Florida is going to interpret this, but I presume, again, that, and I think we need to conservatively act based upon what's going to be the broadest interpretation of the law.
Okay, keep going, I think.
So then we look at the penalties. Department of Economic Opportunity is going to be the state agency that enforces this act. And as you can see there, if an employer fails to use E-Verify 3 or more times in any 24-month period, it can fine you as an employer $1,000 per day from the date that they determine that you fail to use it. So if they come and audit you, and the enforcement, again, to start with, is not going to begin until July of 24. So moving forward, if you are caught not using E-Verify 3 or more times, and an audit occurs in December of 24, and the first employee that you hired in July of 24 did not have, you did not E-Verify, and then the fine will start then.
Let me ask you a quick question here, Angelo. July 1st of this year, the law takes effect, but there's no enforcement until July 1st of next year. Am I misunderstanding that?
No, you're not misunderstanding that. And this is typical of labor laws that create new obligations. Typically, the law will provide a period of time for employers to come into compliance. And so enforcement within the statute itself, enforcement will not begin by DEO until July of 24. Now, that's not to say, and this is an interesting question, going outside of my example, since the act is effective July 1, 23, if you don't E-Verify 3 times in July of 23, and they come and audit you in July of 24, does that mean you owe $365,000? That may very well be.
Is that only the E-Verify piece that has that grace period, or does that include the human trafficking piece and some of the other aspects?
No, I'm talking about the employer obligation, the E-Verify.
Okay.
Okay. The statute itself lists a number of enforcement agencies, including law enforcement. DEO is the agency that will be enforcing with respect to employers, based upon my reading of the statute. Obviously, with respect to the trafficking question, that would likely be law enforcement. And we'll get to the trafficking issue, but again, that's to start with, that's trafficking into the state. Okay, because I know I've heard a lot of people who have told me that there were concerns with carpooling issues where employers are asking someone to drive individuals to the work site, as long as they're not coming from out of state and driving into the state, they are not violating that aspect of the law.
So that I know we'll get to that later, but that is absolutely one of the areas that you hear this law being exaggerated and misconstrued by the media and social media. I mean, I saw an activist, supposedly an educated person, talking about how you can get arrested for bringing someone to Disney World or to the hospital. So I think it is an area that hopefully we'll spend a little bit of time getting the facts straight here, because I think there's a lot of fear that's misinformed on that.
Right, and I mean, there's also a lot of fear with regard to, there's healthcare providers are now required to obtain information with regard to citizenship, let's say, but there's no reporting requirement. So again, there's a lot of fear that that information is going to be used for purposes of deporting individuals. That remains to be seen. I mean, this is a law that in a number of aspects is going to be very difficult to enforce, given the manpower with respect to the agencies that are charged with enforcement. And there's also a question, whether or not the purpose and intent of the law is to provide a means for deporting someone. Deporting individuals is the province of Homeland Security. It's not the province of the state. And there's very rarely, in my experience, cooperation between the feds and the state on issues like this.
One of the questions that's come up a couple times, and I've thought about it myself, are there aspects of the bill that we anticipate being challenged in the courts?
This particular part of the bill that deals with employers, the answer is not likely, since it provides for the same type of employment verification requirements that the feds provide. So it's not as though the state is taking a law such as IRCA and expanding it beyond what it's entitled to do under the Constitution. So in this instance, with respect to the employment issue, the answer is no, unlikely that there'll be a successful challenge. That's not to say that there won't be challenges. We haven't seen anything yet, and implementation is only a couple of months away. I think the issues relating to trafficking in healthcare might be a little more dicey, but again, I don't know that. I mean, certainly the trafficking issue being a criminal issue, that's something that's certainly within the province of the state to enforce. The healthcare issue, we'll see. I think that's one of the one piece that's most likely to be challenged. There's also within, as you see on the screen, the DEO, if they determine the failure to use the system, could suspend licenses until the employer provides proof of compliance. And there are specific periods, but let's talk about knowingly. So if you knowingly hire or employ, and I highlight employ there because of this is another question that remains to be seen, I think, but when you have to presume that when the legislature puts a word in, they intend to have some consequence result. And so again, what we've been talking about up to now is the hiring process. So when you hire someone, if you have more than 25 employees, you have to use E-Verify. If you employ someone, though, who is not authorized to work, there are certain penalties that can be attached to that, such as repayment of economic development incentives, revocation of licenses, a one-year probation and reporting requirement. And so let me go back to what I was saying in the beginning in terms of us focusing on our hiring process. If you have someone who has an permanent resident card or an employment authorization card that expires, and this law requires you to keep that document, you should know that that employee is no longer authorized to work. So if you strictly read this section, you are now employing someone who you know is not authorized to work. Now, for those of you who have some experience in this, there are extensions that you can get or that the employee can get by simply petitioning to re-up their employment authorization card or their permanent resident card. And those extensions are 240 days from the time they petition. And so you can retain that person's employment for that period of time without them having a card that is currently active, as long as they've petitioned to get a new one. But if they have not, and you continue to employ that person, then there is some thought that you would be in violation of this section of the statute and would be subject to the penalties. Right.
So Angelo, staying on that topic and tying to a question in the chat, when you receive that information as an employer, you receive the updated documentation permitting the continued employment. Do you need to go through the E-Verify process again with the updated documents?
Not under this statute, no. No, if you have done it, oh, there are two potential circumstances. Let's say this is a person who you employed prior to this statute. The answer is, well, the answer under both scenarios is no. You don't have to go through E-Verify. You're not rehiring the person. This is not a new hire or a rehire. This is a person who was employed, who at the time they were initially employed, within 3 days, you obtain documentation, which you either saw was reasonably genuine and filled out an I-9, or who we verified at that time, and they passed muster. And so that person was legitimately employed by you, and now their authorization has expired. You're not rehiring them. Okay? You're simply continuing to employ them. If, however, they have not petitioned, or they petition and are denied, then you must terminate, or you can potentially knowingly have someone on your rolls who is unauthorized.
So construction specific, obviously any project has dozens, if not more, construction trades and of different types out there. Do you have any obligation regarding compliance for companies that you contract with?
You mean subcontractors?
Yeah, exactly.
No, you do not. Those are not your employees. Okay, they are the employees of the subcontractor, and the subcontractor is the one responsible under the statute. Okay, statute, again, we're reading the statute literally, and literally it states that you are an employer or an employee, and this applies generally across the board with respect to labor law. Most labor laws make the employer responsible. There is a situation where you could potentially be deemed a joint employer. And under that situation, perhaps there can be some risk. But in most instances, when you're dealing with a subcontractor, that's not going to be the case, even if you have some control over their work. As long as you're controlling results and you monitor and you're not controlling tasks.
What about things like temporary employees and 1099s?
A temporary employee is an employee. Okay, and so this would apply to temporary employees. Just as in OSHA, where you have temporary employees, I mean, you know, this is many of you probably know this is one of OSHA's focuses in the past few years, is that they're looking to see that we're training temporary employees on relevant topics with respect to risks in the workplace. With respect to independent contractors, they are not employees. So the answer is no. If they are a true independent contractor, then you would not have any obligations under this statute. Keep in mind that the rule is out there right now, promulgated by the Department of Labor with respect to what is an independent contractor, which will re-expand what an employee is as opposed to an independent contractor, and make it much more difficult to show that an individual is an independent contractor. And that's a topic for another seminar, but independent contractors, just for purposes of this statute, are not covered. Okay, so if a violation of the statute, and this is the knowing requirement, it takes place within 24 months after a previous violation. This is, I guess, the ultimate hammer that they have, which would be to suspend licenses, depending upon the number of employees that they find that you have failed to comply with the statute on. 1 to 10, your licenses will be suspended for 30 days, 11 to 50 for 60 days. If there are more than 50 employees, that would result in revocation of your license or licenses. Okay, is this the human smuggler, which I think I spelled wrong, is any person who knowingly and willfully transports an undocumented individual, and here's the key, into the state, who knows or reasonably should have known the individual's immigration status. This is the only part of the bill that provides for criminal penalties. But again, it's only with respect to transport into the state from outside the state. And then finally, the state will refuse to recognize driver's licenses issued by another state to undocumented individuals who were unable to prove lawful presence in the United States when the licenses were issued. So if the individual does not have a valid employment authorization card of some type, or does not have any type of authorization to be in the United States, such as a visa, then the state will not recognize a driver's license that they may have that was issued in another state. Now, if you have individuals who drive for you and they were hired before this statute went into effect, then they're okay, because you have examined documents which reasonably appeared to be genuine, which established their lawful presence. If you e-verified them after the statute, again, they're okay, because e-verify cements the right for them to be present in the United States, at least during the time that those documents are in effect. A lot of questions with this as to whether or not, if an authorization card expires, does the driver's license expire? We don't know. This is perhaps one of the challenges that may come in the courts. There are constitutional challenges on the right to travel that may come about as a result of this particular provision. That's a wait and see. Okay, I'll take other questions.
So one of the questions here is, if an employee provides false documents and it turns out they're false later, is the employer somehow accountable for that, liable for that?
I presume that the question deals with a situation where the person was employed prior to the act taking effect, because because they have less than 25 employees and don't have to e-verify, because once you e-verify, you know whether or not the documents are valid. Again, if it was before and you did not e-verify, if the document reasonably appears to be genuine, okay? If you look at a Social Security card and the stamp on the card is lopsided, that does not reasonably appear to be genuine. But if it looks like a Social Security card, smells like a Social Security card, and otherwise reasonably appears to be genuine, then you are not going to be held liable. No.
Okay. I'm just going through the chat, trying to find things that you haven't touched on. Um, let's see. Can you please find out if after July 2024, there'll be audits performed periodically for existing employees that were not e-verified because they were not new hires when this started on July 1st, 2023?
The audits, Homeland Security conducts federal audits. I've been involved in numerous Homeland Security audits. They generally ask you for all of your I-9s. And remember, you need to keep these I-9s for that 3-year or 1 year after termination, whichever is longer. Those have to be maintained at the very least under the federal system. You don't have to keep the underlying documents, but I recommend you do. Homeland Security looks at that very closely. Again, the federal system does not require you to e-verify at this point unless you're a federal or contractor or a public employer. But their audits do not focus. They will look at no match. I mean, if you've gotten no match letters, they will look at that. They will look at any underlying documents that you do have. If they find that there are Social Security numbers that do not match, but they will penalize you monetarily, but they typically do not deport anybody that I've seen, and I've done many of them. The state, it remains to be seen how they're going to audit. I think the state has information, and again, this is going to be reliant on whether or not the state shares with each other, each agency. So the state has information about your hires. Okay, you have to provide information to the state whenever you hire someone, and so they will look at that and perhaps target certain industries. One of them obviously are going to be construction, and do spot checking to see what they can find. Now, whether or not they're going to coordinate with Homeland Security and obtain information with regard to E-Verify, that remains to be seen. I seriously doubt it, but it's possible.
One last question. Are there any new risks with this law if an employee is hurt on a project site and has to be brought to seek medical care for any of the people in the respective chain there?
If that person goes to a medical provider and cannot provide information that establishes that their presence in the U.S. is lawful, then the question becomes whether that information is going to be gathered by the state and shared between agencies. That, I think, is, from a practical standpoint, I think that's a long shot. But I cannot say that there'd be absolutely no risk there.
Understood. So it seems like there's a lot to be determined with regard to how this thing actually gets enforced and implemented.
Right, and we're not going to know until 24 when they actually start enforcement. Again, I think there were motivations for this law, and I don't know that it was particularly thought through in terms of all the implications. The issues that we've been dealing with as employment lawyers for years relating to Homeland Security and how they enforce the immigration laws and the requirements to verify, for employers to verify. I don't think any of that is going to change. I don't see the dire implications with respect to enforcement that maybe there are out there in, that the pundits are expressing. I just don't see it. I do think that, there's going to be an initial rush with respect to enforcing this, particularly since it's going to come in the middle of the presidential campaign. And so we're going to see they'll probably go and audit Disney to see whether or not they are.
I'm sure you're right. One of the things that Carlos and I have been trying to do is around the trafficking piece, getting more clarity into the world, right? I mean, this is the most misreported piece of the law, as I mentioned earlier, and just in the spirit of this conversation, we wanted to put out some messaging in Spanish for the people that are fearing this law and the trafficking element of this law. And I will tell you, we talked to a variety of immigration lawyers, and none of them wanted to go out and say, hey, you shouldn't be scared of this piece because the enforcement is so unknown at this point. So it's a concern. It'll be very interesting to see how it plays out. But I will tell you, your counterparts on the immigration side are very concerned that law enforcement will use this as an opportunity to maybe get in people's business that they wouldn't be able to otherwise.
Right. And, again, the statute is clear into the state,
Yes.
but we don't know how broadly that's going to be interpreted, whether or not, for example, interstate commerce there's always been a question as to whether or not, and this has to do with labor law too, whether or not interstate commerce ends where the first stop is or the final resting place. And so if someone is traveling from out of state and comes into Florida and is picked up by somebody in Jacksonville and then transported down to South Florida, is that into the state? I don't think so, but if you really want to get hell-bent over trafficking issues and try to get some play on this, then perhaps that's how it's going to be interpreted. But that remains to be seen.
Well, thank you so much, Angela, for your time. This has been tremendously informative. We always appreciate your support, but jumping on this in a timely fashion, trying to help our membership is, I know, deeply appreciated by me, the board, and the association in total.
You're welcome.
Angela, if folks have follow-ups, because I haven't been able to cover all the questions, how best to reach you?
Just through Kelly Cronenberg. I'm on their website. You can reach me either by contacting the firm. I'm in the Fort Lauderdale office, or you can give me a buzz on my cell. I will give that out. It's 954-401-1814. It's 401-1814, and I'm available anytime to answer questions.
That's awesome. And if you need to reach Angelo and you can't reach out to Vanessa, me, or Carlos, and we'll certainly make that connection for you. So thanks again, Angelo. We appreciate your time.
My pleasure.
So we do have an informational piece that we put together that we will be sending out to everyone who signed up for this. It's a two-pager, one page in English, one page in Spanish, that provides kind of an executive summary of all the components of the law. It is something that you can disseminate and share with your employees, with your subcontractors and their employees. It's on AGC letterhead with our logo, so as not to put any of our members in anybody's political crosshairs. But it does lay all this out in pretty plain language and should be helpful as we try to better understand and navigate this law. So you'll be receiving that via email if you've signed up for this webinar, as you all have. One last piece of news, we have our fishing tournament coming up June 23rd through 25th at the Faro Blanco Resort in Marathon. It's one of the highlights of the year as far as the AGC YCF calendar goes. It will be an absolute blast. People go, they have a great time. Even if you're not going to go fishing, don't have a boat, it's still a great time, good time to party, and bring your family down and just enjoy a nice weekend at a beautiful resort. Hotel rooms are running short, so if you're interested in joining us, reach out ASAP so we can help you get on board. And if you want to sponsor the event, we got those types of opportunities too. So, reach out to me, Carlos, or Vanessa, and we will get you teed up. Thank you guys all so much for your time today. We really appreciate it. And thank you for all the support that you provide for our association. Have a good day.